You seem to be planning to say something, Mr. Sikhakhane.
Banning, I'm not banning, but there were preliminary issues I had said I was to present together with the first one that has been determined. But I'm not banning, not yet.
Not yet.
Not yet.
I think it's appropriate for us as tribunal to say that, let it be clear, this is not, what is right here is clearly comes from the lead of evidence. And let it also be made quite clear that at this stage, we do not necessarily agree with everything she's saying in a statement. That said, go ahead.
Thank you. Chair, we will let the case crystallize and we will make our statement on the merit when the case has crystallized. The issues I wanted to raise is if one would call housekeeping, and they're not going to delay anything. It's just for the evidence leader to take note of because they're outstanding, but they're not for the panel. I think it's first is the fact that I think we've submitted our 2 files, which are the respondents' files. Secondly, there are outstanding issues. That is the witnesses to be subpoenaed, and that clarity, I think the evidence leader will know which ones are outstanding. We have no clarity as to that. Linked to that particular issue is a letter that is necessitated by a recent correspondence from Ms. Muretwa on the issue of witnesses, and we that when they do that, because that also includes an issue of what necessitated by Ms. Muretwa's recent correspondence, the former CJ Raymond Zondo be subpoenaed, and also the other issue is what was unresolved was an identification parade, and where one doesn't know what happened to that. I think she was to do that, and then the other thing was the viewing of footage. There is no joint minute in this regard, but I think that can be talked about, and the tribunal, in our view, should view the footage itself. And lastly, that there are further downloads of cell phones that relate to particular dates, and I think the expert, I think it's Mengo, will have to deal with it. So I'm raising that's for the dates, the 28th of June in particular, and the 18th of September 2022. 28th of June 2022 and 18th September 2022. Chair, I was raising this so that at least there is clarity about what is outstanding, but it does not delay the process. As to our opening statement, we will hear what the case is, let it crystallize, and we'll make our statement at the right time. And Chair, I just admit one thing. We do this about who's leading in proceedings like this, the evidence leader does not represent the complainant. And we raise this because it's an important oversight in this country about what the evidence leader does. We raise these issues because the evidence leader does not represent the complainant, but helps this process, helps us, helps you crystallize the evidence. It's that old principle that a prosecutor, even a prosecutor, is not here to vociferously seek a conviction. So we raise this because most of the witnesses, in fact all, belong to her. She must lead them to assist this process, and we would require the list when it's finished. Can I just take a... My learned colleague reminds me that we will give a list of these outstanding things in a form of a letter. We will give it to the evidence leader, and the panel will get a copy thereof. Thank you.
We will deal with them as they come. Hopefully they'll come with a full explanation so why you did not raise them all along and only raise them now.
We have. They were raised. That's why I call them outstanding.
Let me deal with one of them. Yes. You call them outstanding, and it may well be that it's somebody's fault that they're outstanding. We'll deal with each one of them if and when they come.
Thank you, Chair.
You referred to a list of witnesses. I think 3 or 4 months ago, I asked the parties to submit list of witnesses shortly after the or prior to the hearing. Your side, in other words, your side was also asked to submit a list of witnesses 3 or 4 months ago. You submitted them only last week. You gave reasons. There were reasons. I've seen some reasons, totally unconvincing and unacceptable reasons why you were not able to comply with the directive that you must submit a list of witnesses within that given time. I've read some flimsy reasons why the names were not given. So you need to be very careful when you try to suggest that there has been some neglect of duty on the part of the leader of evidence to arrange for the calling of witnesses. You submitted a list of about 10, 11, I don't know, hopefully not 100 witnesses, only last week. We did our best to issue subpoena and have them served on those witnesses as best we could, because you submitted the list only 2 weeks ago, or in fact last week. So we need to be very careful when you raise some of these issues. The tribunal is still to this day being owed an explanation, if not as a matter of courtesy, but certainly as a matter of law. Why many months ago we asked you to submit a list of evidence and then you aside, you're not in the matter, but the list was not given. As I repeat again, some unconvincing reasons were given as to why the list of witnesses could not be given. Not even one, not even two. I can tell you, after the Secretariat received your belated request for to subpoena certain witnesses, they contacted me, and we tried our best telephonically to try and meet your request to subpoena those people, and we did our best. So we need to be very careful before we throw stones here. There are a few other things that may still arise in the manner in which these proceedings were conducted, or in fact, accurately, failed to be conducted. As for these other things, Zondo and the like, we'll deal with them as they come. I'm not sure in what context Zondo should be subpoenaed. But as for the other things, the identification parade, I don't want to respond to that, because, except to say this, for you to know to conduct an identification parade, you had to know who was on duty on that day. For you to know who was on duty on that day, you must be given a date of the parade. It's an open issue as to whether or not we have got a particular date of whether a particular incident happened on this or some other day. These are the issues that we hope to deal with as we go along. We don't want to try to solve them in anticipation. The matter must be allowed to take its course, and we'll deal with those issues as they come. You may have to explain to me about the issue of subpoenaing the former Chief Justice. I'm not clear about it.
May I speak, Chair?
The context.
Yes, Chair. Chair, let me start here. The use of the word outstanding issues, and then I must address it to my learned friend, Advocate Skippers. It was not, these are issues outstanding. I did not intend to say she's not done her job. I was saying these are the issues that will be dealt with because we have in there outstanding. If I communicated that I'm suggesting that she has not done her job, no, I can't speak for why issues are late. I'll take instructions, but I was not attacking her at all. I hear that the chairperson may have misconstrued the use of the word outstanding. It was not directed at her. So I can't answer for that, but I can answer for the fact that the lateness, I don't want to argue the merits of this point, but the lateness of the letter that seeks to subpoena the former Chief Justice is necessitated by another letter that has come from an official in that office who states certain facts that can only be ascertained with the former Chief Justice himself. But I don't want to argue the matter. I was just raising it. And I'm sorry again to Ms. Skippers if my raising of this issue was suggesting she hasn't done a job. That was not the message. Thank you.
Yes. You are going to, when the time comes, you are going to have to make out a case for the subpoenaing of the former Chief Justice.
I will, Chair.
It's not just there for the taking. You'll have to make out a case for it. And you'll have to consider the relevance of his evidence, the importance of his evidence to the issue that is before us. You'll be given the opportunity to do that in due course.
Thank you, Chair.